All right. Welcome to the next episode of IP at Lunch, a 10-session micro webinar series for entrepreneurs, creators, and small businesses. My name is James Greenwood. With me today, I have Phil Schaefer. Phil is our of counsel for IP here at Greenwood Law. I am an attorney licensed in Iowa and Illinois. Phil is licensed in Illinois. Phil is also licensed to practice before the USPTO as a patent attorney. So before we get started, this is a quick reminder that this is a webinar for educational purposes only. You should not be trying to use this as legal advice. You should get your own attorney and ask that attorney any specific questions you have about your specific concerns. If you have any questions or concerns about today's topic or today's webinar, you can direct them to me. My name is James Greenwood. I can be reached by emailing at james@greenwood.law or web@greenwood.law. I can also be reached by telephone at 855-528-6022. Phil, thank you so much for taking the time out today to join us, and I'm looking forward to hearing from you. Can you tell me, just in general, what really attracted you to IP work? I mean, just high level, what got you into the work in the first place?
Yeah, it's very simple. I just love ideas, and what's exciting about them to me, and there's that's a very broad word, as an idea, but just any sort of creative expression or the use of the mind to produce something, even though it's intangible. The fact that you can assign value to that, and individuals can do so, society can do so. That's just really a cool concept to me that that sets human civilization apart from other groups of organisms. So that's about as broad and high level as I can get with it. But that's what the excitement is.
I love it. And today's topic is actually, kind of relevant. This is kind of a relevant topic here. I know that I had, provided, before the meeting, I had sent out a talking points thing, and I realized afterwards, I was like, golly, these are totally, yesterday's, topics or Wednesday's topics. These are our copyright basics for creators and marketers topics. So Phil, I apologize. I'm going to basically.
No, I knew, that's okay. I saw it. I saw it, and I knew that we were still talking about copyright. So I figured what had happened was just an inadvertent send. So I am A-okay to talk about copyrights today, regardless.
I love it. Yeah. So let's start with the basics. And you talked a lot about loving ideas. And so this is a great opportunity to kind of talk about ideas. What the heck is a copyright?
Yeah. Well, a copyright, and this is how we preserve the value. That's how I keep my excitement, is that we can preserve the value of that idea through a copyright. So a copyright is a legal right in a creative expression that was made by a human author, and then put in a fixed medium. So that if you hit those marks, then you have something that's protectable. And so what most people immediately think of is something like a song or a poem, a photo. It's just something. It's more on the artistic spectrum of IP than, say, a steering dampener patent filed for an automobile. So this is where we have many creative expressions protected as through copyright. And what's
Okay.
very interesting. Sorry, go ahead.
So what are the common things that we typically see protected by copyright? What are the things that usually stick out? and you should, something comes into your office, somebody comes in and they're like, hey, I've got a great idea for a blank. What would be the common things you would expect to see?
Yeah. Usually that's related to marketing. So the content we use for marketing, that would be a picture, a website, website content, song jingles, those sorts of things. But they can be just material prepared that don't relate to that, such as a business report. Really anything that can be creatively expressed is eligible. One thing to note about that is, excuse me, there's it only protects the expression of the idea itself, not the idea. So if I host a podcast and I record it and publish it, I have a copyright on that podcast and my expression of the views or topics, but I don't have a copyright or a protectable interest on the topic itself. So that's very tricky to wrap your head around, and it's not very intuitive, but that's a key hallmark of copyrights.
So I can't copyright the information in the phone book, but the way that I lay the phone book out, and this I'm showing my age here, right? I know what a phone book is.
The phone book, yeah. The thing that we're I don't even, well, I think phone books have more use as booster seats now than they do for actual reference. But anyways, no, you're right. That's a perfect illustration of that concept.
Okay. So what does a copyright just not cover? So we talked a little bit about the underlying ideas, facts, the kind of concepts there. We talked about a little bit of the functional elements. So we kind of talked about that. Let's talk about protection and registration of copyrights. When does a copyright come into existence? When do I have a right to the thing, this thing that's been reduced to this tangible medium? Is it, do I have to register that to get that protection, or do I get it automatically? How does that happen?
You get it just if you're the creator, you get it just out of the mere act of creating the work itself. So once it springs into existence, and you create the original work, you have the you're the copyright owner. Protecting it is a whole different ball of wax. So in order to protect it, that's where registration comes into play. So that's where the Copyright Office, which by the way is closed because of the federal government shutdown, whereas the USPTO is open. So that's kind of a funny paradox. But anyways, that's where the U.S. Copyright Office comes into play, is it serves as the registrar for registration of those works.
Okay. And it's worth noting that if a copyright's registered, you get some extra protection, right? You get I think there's statutory damages. I think there's attorney's fees, right, as well, usually, if somebody violates copyright. So if I were to, on here sing a Taylor Swift song, I think that, as much as I may butcher it, it could potentially, get me in hot water from a statutory damages and attorney's fees standpoint. Would that be an accurate statement? If I don't
well, I guess it depends on how good it is and how big the audience is. No, I'm kidding, but potentially you're right. There was one thought it's escaping me, but I wanted to mention it too. It'll come back to me, but no, that's correct. And then there's certain exceptions to the use of a copyrighted work. And one of the most common would be criticism or comment. So just because you have you're discussing or reproducing or otherwise using a copyrighted work, um, it it doesn't necessarily mean it's unlawful if it's falling under an exception category, which
Right. Fair
could
fair
be something like,
use
yeah,
and is what you're really talking about. And we'll talk about that next week in
yeah,
depth.
okay.
Um,
Um,
that's
but
it.
that those are things
Very
like
topic.
creating a parody of something,
Okay.
for example.
Perfect. Yeah, and oh, parody's a great one. So I think that covers the entire Weird Al Yankovic catalog.
Yeah, and
Dating
he's
myself
good to go. He's locked up.
there.
He's on the
So,
up and
all right. So, let's talk about um, you know, common marketing scenarios, things where we maybe might run into this in the real world. And I think one of the things that I see a lot is people will just go online and grab photos off of wherever and not bother to do attribution. They don't do whatever. And then they throw those photos on their websites and then they go to use that website for business. Um, can that be a problem? And why? Can you just kind of talk about that for just a second?
yeah, it can very well be a problem because um, if you were to do that and it's a copyrighted subject matter, to do so without permission would be copyright infringement, and so you're opening yourself up to legal risk of and liability of damages for whatever may result of your use of that. Um, and the internet being the internet, you don't really know where the lines are of what's in the public domain, which is okay. That is something that's okay to use, um, versus something that has copyright protection. So, um, yeah, very much word to the wise is I would not go pull something off the internet to reproduce um, either in whole or in part, without really looking at whether it's in the public domain or you have some other allowance for using, which again we can talk about in future webinars. But that's really running a big risk, or it could potentially be running a big risk if you were to do that. Um,
Yeah,
and,
and I
and what I
think
mean by public domain is it's open for the public to use or reproduce, and it's not under any sort of copyright protection.
right, and of course the gold standard of this is, if you've got somebody who can create their own content, that's the gold standard, right? Because then they've got the copyright inherently, they've got the right to the thing and if you're the copyright IP maximalist, that's how you do that. For the
That's
rest of us who can't produce that quality content, maybe going to a licensed and pay for licensing site, a legitimate pay for licensing site, and purchasing the content might be the best, or the rights to use that content is probably the best way to make sure that we don't violate those copyright rights of the artist themselves. And so, and the thing that I think that everybody in my generation is familiar with is these old Napster lawsuits, which again, I'm dating myself, right? The kids don't know what this is, but
Yeah,
back when I was back in my day, we're
burning
sounding like
CDs.
that. We had a lot of people get sued over basically downloading unlicensed copies of songs and
Yeah.
videos, and it was a big deal. So, and let's talk about something that's really relevant today. Um, Background music in videos. I mean, these short form videos, they all got this background music going on. What is going on with that? I mean, um, is that potentially problematic if we're going to be using it, especially if we're using it for business purposes and making money on it? Is that going to be problematic?
Um, Well, okay, so if we're talking about like YouTube Shorts or something, there could potentially be a licensed allowance to use that. Like, so if I know some social media outlets allow you to just pick a bank of songs to plug into your video that you're making. And I haven't gone to check for myself, but I would imagine that there's a license to be able to use that and to sample that sound for the creator.
But I
If you're
think the
doing,
important thing here is make sure that we've got the right kind of license, the right kind of
yeah,
account. Because if you're a business account, I would have to take a look at each service respectively. I would imagine if you've got a personal account, it's probably got different licensing than the business account in there.
right, exactly.
So
Yep, and that's the other thing too, and this isn't really something I've um personally looked into for personal accounts, but yeah, just different registration of accounts could have a different span of license, and I know that James, you and I are using that word license pretty liberally here, but you really can't talk about copyrights without talking about licensing, and I think that's key. That's a key takeaway. Is even though if the work is not yours and you want to use it, think license. And you want to make sure that you're set up to do that, whether it's by making sure that you have the appropriate account registered and are acting in accordance with those policies that in social media, or you're you're making sure that you're purchasing that license through a database of pictures, like we had talked about earlier, um, uh, or otherwise just making sure that the subject matter isn't copyrighted and is in the public domain.
absolutely. And I think you know there are definitely from a licensing standpoint, there are definitely a lot of different ways to license this content. And one of the nice things that these platforms a lot of times will do, assuming that you have the correct kind of account, is they do serve certain things that you are allowed to use, but you should read the license pretty closely, because the other thing that you might be doing, and this we ran into this with one of these photo sharing sites a little while back. They had a thing where basically they said, oh yeah, if you, and photographers just went bananas, because they said, oh yeah, if you upload your photos to our site, we get a irrevocable, not fully transferable license and right to use this photo however we want
Yeah.
in perpetuity forever, basically. And oh yeah, we can transfer this as much as we would like. So
Yeah.
go ahead.
Go ahead. No, that just sounds very unfavorable to the person that uploads it and wants to preserve the exclusive
Right.
right.
Right. Yeah. And I think a lot of that stuff ended up being training data for these AIs that
Yeah.
have come around. And let's turn to those AIs for just a second. And I think something you said is important when we're talking about that AI and that use, and maybe you're creating something and you're prompting this AI to produce something for you. If I prompt an AI and the AI spits out this image, do I hold the copyright to that image?
Potentially, and that is a very timely hot potato right now. So if there's and for it's very fact specific, and there's factors that are weighed out to determine that. But if If an author is using AI to assist in the creation of that expressive work, um, it's looked at as simply using technology as other advanced technology that is just simply more advanced than what we had 10, 20 years ago to create that. But then if all you're doing is providing a prompt of, say, write me a story. The Copyright Office has weighed in on this with a report, I believe, published in 2023, or no, I'm sorry, it was actually January 1st of this year. The Copyright Office published a report which their view and perspective on the matter is simply providing prompts to AI is not sufficient to create authorship, human authorship, and be an original work for it to be copyrighted. So that question exists on a spectrum, and I can't necessarily give black and white rules all the way through, but
and I think it's worth noting, and you said this, and I want to emphasize here, this exists on a spectrum. It's hot, it's new, which means a lot of this stuff hasn't been tested yet. So we don't know, a lot of times, if you're using an AI, we don't know what the outcome, we don't have certainty about what that outcome may be. And so we may not be able to say, oh, yes, you definitely own this thing. It may be one of these scenarios where we say, well, you may own this thing. There may also be some of it that you may not own because of how you did this. Is that what I'm hearing here?
Yeah, certainly. It might not just be a question of owner. Well, so it may not just be a question of ownership. I think that would be the easier thing to determine, which is the terms and the terms of usage of whatever AI resource you're using would likely touch on who owns what. And so I think that's an easier answer to arrive at. But what the real question is if it's original or not. And so that plays into whether it was human created or created by a means otherwise, and involves some sort of creative spark. So there's this famous case, I believe it's a U.S. Supreme Court case, where it was determined that a monkey that was messing around with a camera. So pictures, photographs are you can copy. You have a copyright on a photo. It's a creative expression in a fixed medium. There was a monkey that was just messing around with a camera and took a picture. Maybe it was of itself or something else. But anyways, that picture was found not to be copyrightable because it wasn't taken by a human. So it really comes down to how that work originated, and is more of a question of that rather than who owns it.
Okay. And in the last few minutes here, I am going to, interject one last thing here. Let's say that I hire somebody and we have a contract that says, hey, you're going to create this thing for me, but they're a contractor. And the rest of the, other than it saying, hey, you're going to create this thing for my use, the contract is silent. Who owns the copyright and who has a license in that case? Usually.
So, yeah,
that's the asterisk that there could be a million iterations of this, typically,
yeah. So I'll just answer this generally, but that's, James, what you're talking about, and I'm glad you asked this, is we're talking about works for hire, whether it's a contractor or so I'm thinking like a wedding photographer. I don't know why my mind goes there, but I just go to wedding photography for whatever reason. or they could just be fully employed. But if there's a work for hire involved, and the agreement is silent, um, the uh, the ownership of that work goes to the employer, or the person that's doing the hiring, or the person that hired the individual to take the picture, create the website, or whatever, so long as there isn't anything else saying otherwise. And so that's the person that would allow that has the discretion whether to grant a license for use or not. So there's many ways that those agreements are written to allow for a range of licensed use. So like that wedding photographer might say they might be silent on ownership, but what they might do is put in something that grants them a license to use only for the purpose of marketing their own business. So it comes back to very specific languages of contained in those agreements for works for hire.
Absolutely. And so work for hire, that's something we run into a lot, both for the creative side and for the folks who are hiring a potential creative person. I think I've gone through a number of employment agreements, and different people have negotiated different things. That tends to be something that employers are often willing to negotiate because they don't really care. Many times they don't care because it's not core to their business and entirely necessary that the creative use is restricted or owned by them. They just care about having a license, and oftentimes our creatives are willing to may negotiate that so they can use that for their own purposes, or maybe even retain ownership later on in their careers. So it's certainly something that we've
Exactly.
seen out. The last thing, just real quick, let's say that you've got something, you've registered it, create a copyrightable work, you've registered it, and somebody has, used this, I'm the next up and coming, musical artist. And in my infinite wisdom, I wrote the next, hit song, and I have not agreed to license it to anybody for their short videos. Can I do anything when Jimmy Joe down the street posts it up on YouTube and his YouTube channel blows up because he uses it as a background to his dance song or his dance video? Can I do something about that if I wanted to?
Well, as long as the exception for fair use is not met, you certainly could. And what that typically starts with is a cease and desist letter to notify Jimmy down the street to not dance to that song. And from there, as long as you have that mark registered, like you had mentioned, then you could also pursue litigation if that weren't to fix the problem.
Could I just file a DMCA notice as well in I guess YouTube or Instagram or something like that? Takedown notice on that?
That is a good question. So if I'm understanding your facts correctly, I believe you could.
Okay, potentially, yeah. And that's everything here is with the asterisk, you have to look at the specific facts and everything else, this undergirding everything, ownership and all this other stuff. So practical tips here, I think, a couple things that we can glean from all of this. You want to create the original content whenever possible. To the extent that you have to use somebody else's content, make sure that you have obtained a license to that content, especially when you're using it for business and non-educational purposes. Register your works when you do create them to get some added protection there. And, again, emphasizing, make sure you talk to an attorney anytime you've got heavy creative use, some sort of campaign that you want to do. If you're looking to get into a business, something like that, talk to an attorney ahead of time. Thank you so much for joining us. That is it for our public facing stuff today. We are going to go ahead and cut it off. Again, my name is James Greenwood. I'm joined by Phil Schaefer. We are talking about IP throughout the rest of this series. If you have questions about today's content, 855-528-6022 is the best number to get a hold of us. I'm an attorney licensed in Iowa and Illinois. Phil's an attorney licensed in Illinois and before the USPTO as a patent attorney. Again, this is not for an attorney. This doesn't form an attorney-client relationship, and it should only be used for educational purposes. You should not rely on this as legal advice. Thank you so much for joining us today. Have a great day. Goodbye.
Thank you.